Mr. Barker, you said to my colleague here, Judge Corriero, that your actions in these text messages, I was hoping you were going to say no when he asked you whether they were appropriate or not. You can't stand here today, actually, and tell us that what you were saying in these text messages, which I'm not going to repeat, were productive. I understand you were upset, but it wasn't productive. But I will say that some of it was decent enough for me to read. Mr. Barker, you say you clearly have no morals. You should feel awful, embarrassed. You will never be blessed for this shameful act. How you're handling the situation, it shows your level of class and how you were raised. I'm not going to read the rest. So, is this in response to him not paying you back?
Right, correct.
Okay.
And if I may add really quick, Your Honor, he's completely lying about not taking care of him. I gave this man CPR in the front seat of my car and saved his life the second heart attack.
So. That's not a favor, sir. I would hope you do that for
that's not a favor,
anybody.
but I'm saying that just proves that for him to say that I never took care of him and I may have visited him is completely untrue. I revived him for them to get a pulse. When he was in the hospital, I was there every single day.
Again, this is something that you would do because you're a human
Absolutely.
being.
But it's nothing about the money. It's just for him to be like, listen, dude, don't lie and say that I wasn't there for you because I was.
Okay. Anybody else got anything?
The Zelle payment that you gave us, Mr. Barker, is dated June 26th of 2021. Was that when you got the first payment?
Yes.
And this would be approximately 4 years after you extended the loan to him. Is that correct?
Yes, but not 4 years after that we had made a verbal agreement that he would be paying me back, though. So I'm still under that statute of limitation.
I'll have to discuss that with my colleagues.
Yeah.
Are we good?
Yeah.
Okay, we're going to excuse the parties while we deliberate in this case. Thank you very much. Don't argue with each other on your way out.
I think it's up to us, not the plaintiff, to decide what's relevant in this case. Okay, but the plaintiff does have somewhat of a decent point, right? A lot of the back and forth history here, the plaintiff clearly did not handle himself well. But this really comes down to whether or not this was a loan. And I think we have to evaluate the credibility of both parties regarding what they said at the time. And then we have to look at this issue that the defendant started to repay the money back. The plaintiff paid for a lot of things during their relationship. He has this one amount that he had to take out a loan himself for that he wants paid back.
Yeah.
And that, to me, lends credibility to his claim that this was a loan. So I'm interested to hear your thoughts.
I was going to say, we have a lot of these issues come up in a lot of these cases that we see in that one party does something for someone else and expects that person to do the same, when you should just be doing things because you want to without that expectation. It's important that you make it clear what you're loaning somebody is either a gift or an actual loan to be paid back. And I do believe that the plaintiff made that very clear, especially given the age difference and him having a child, and $3,000 is a lot for a single dad. I believe the defendant believes in what he's saying. I don't believe he's here lying intentionally, but I just have to give more credibility to the plaintiff.
Yeah, I think the fact that the plaintiff went out and took a loan and is accruing interest on that loan, I think is reflective and supportive that the money that he gave to the defendant was indeed a loan. And one of the bases for tolling the statute of limitations would be a payment within the statute of limitations period. The plaintiff alleges that the defendant did exactly that.
Yeah, but we still have the $500 interest payment to worry about. I do not believe he's entitled to any interest. That February 2021 email where Mr. Barker reconfirms that there was a loan made and that money was owed, it says you technically owe me $2,000. There's no evidence that there's any interest attached to that, and nothing I see that indicates that there was an agreement for interest payments. And in fact, they seem to reach this contrary agreement that in fact the amount owed is $2,000.
That statement, I think, resolves it for me, so I wouldn't give him any additional.
So we're agreed on the $2,000 underlying debt, but not the $500 loan?
Yes.
Okay, we have a verdict, and it's unanimous.